Good evening, everyone. We're going to get started, but I'm sure people will continue trickling in, but we have such a great panel and we want to get this underway. Welcome to the 21st event of the Council for Court Excellence's Bench Bar Media Dialogue Project. We've been doing this since 2009, back when I didn't need glasses to read my notes. And the Dialogue Project started off as a handbook for journalists covering the DC courts, federal and DC court. And it has evolved over time into a series of projects, public and private events, discussing the important issues of the day. So we've done Bench Bar Media dialogues on leaks, the right to be forgotten, Me Too coverage. We had one called Justice on the Big Screen, which was at the MPAA, where we watched film clips, which was a lot of fun. Access to courts during the pandemic. It kind of is a reflection of the times that we've had so many different projects. And this one is on the immigration justice system, which is in the news every day. And even a lot of us who are lawyers, I think, sometimes find the system confusing, complex, and just kind of uncharted territory. So we're really fortunate to have a panel who can help us navigate that tonight. I just want to thank our sponsors, first of all, Williams & Connolly, Errant Fox, which is also, of course, hosting us, Davis Wright Tremaine, Blank Rome, JAMS, and Professor Stephen Vermeil, a longtime colleague who's an individual sponsor from American University. Thank you all. Your support makes this possible. I'm going to hand it off to Laura Hanman of Davis Wright Tremaine, who's the co-chair of this committee with me, and Laura will introduce our panelists.
Thank you, Jim. And thank you. I'm so grateful to our sponsors and to our panel for agreeing to do this. I couldn't thank them more. And I also a special thank you to Zoe Tillman, who is the senior legal reporter at Bloomberg News, who had the foresight to say, months ago, we should have something about immigration courts. We don't know about them. And she was, so prescient. It is never more timely than now. And I just thank her so much for her foresight. And she invited a number of the panel here, and we're so grateful for that. And starting off, you may wake up in the morning and hear Leila Fadel as one of the moderate hosts of NPR's Morning Edition, still a mainstay. And if you're up at 6:30 in the morning, you can hear her on a podcast up first with the 3 top stories of the day. Leila was raised in Lebanon and Saudi Arabia, speaks Arabic. She was involved in the award-winning series Muslims in America, A New Generation in 2019 in collaboration with the National Geographic. She has won many awards for her overseas coverage in the middle of the darkest days in the Middle East. And before joining NPR, she was a newspaper reporter for, among others, the Washington Post. Jim, where did you go? There you are, the Washington Post. Rebecca Walter has been immersed in immigration law for 20 years. Judge Walter was appointed by Attorney General Merrick Garland in 2021 to serve as Assistant Chief Immigration Judge with the Executive Office for Immigration Review, part of the U.S. Department of Justice. Who knew? And she was, as she will tell you, even as the number of people are facing deportation, she was terminated in February of this year. She is now in private practice as a senior immigration attorney at Wilkes Legal. And before her service as an immigration judge, she was a lawyer for low-income immigrants, victims of domestic violence, human trafficking, and unaccompanied immigrant children. partly through a group called Ayuda, where she was a Skadden Fellow. And we are so blessed to have Hamid Ali, who covers immigration and homeland security for the New York Times. You've probably been, he's been a little busy. He's been covering the Dallas sniper. He joined the Times in 2023 after award-winning stints at the LA Times, BuzzFeed, and the San Francisco Chronicle. But what caught my interest was how Hamid got into journalism. And particularly on reporting on immigration. It goes back to when he was 10 years old and he was living in Oregon, and his father was facing deportation back to Iran, and his brother had serious health conditions that would, be fatal if they had to go. And luckily, a journalist wrote in the Oregonian about their plight, and that saved him, and that's why he became a journalist. So it is a great story. And of course, now he's covering troops going into Oregon and many other things that are front and center of what's going on now. And last but absolutely not least is my beloved Lisa Zeicherman, who is now the Vice President of Legal Programming at the Reporters Committee for Freedom of the Press, which is the lead frontline organization fighting for press freedom in the country. And before that, Lisa oversaw local journalists and local media at the Reporters Committee.
I forgot to thank one of our sponsors. I'm sorry. Organized Q. So I apologize for that, but I didn't want that to go.
And Lisa and I were colleagues at Davis Wright and stood side by side together on so many battles for the media and for advocacy organizations like Greenpeace and People for the Ethical Treatment of Animals. I'm so grateful for Lisa's support. And we fought the battle on press freedom for them. And at Reporters Committee, they have a great guidelines for reporters covering immigration. I read through it and learned so much. And they have a hotline so that reporters who are like facing ICE coming down on them or police coming down on them and what to do, call the Reporters Committee for Freedom of the Press and they'll help you. And she also served on the executive committee of the Council for Court Excellence, who is sponsoring this event. There will be time for questions, so be thinking of your questions. And this is being recorded, and just so you know, and I thank you all. We're in for a great treat.
All right. Oh, okay. You can applaud. So I feel really lucky to be on the panel with the three of you, work that I admire and we have covered as well. I know most of you maybe just know my voice and not my face, so I hope this doesn't change your experience when you listen to Morning Edition. I think when I was thinking about this topic, there's just so much that it was hard to think about where to start. And so I wanted to start at the really basic level, having Rebecca on this panel, just about how immigration courts work as somebody who's been both a judge and an immigration lawyer. I mean, what is the jurisdiction of the immigration court? How do immigration judges get their jobs and what do they oversee?
Sure. Well, thank you for having me. I'm really excited to be here with all of you tonight. And I love talking about immigration. I could do it even more than tonight in just an hour-long panel. So the immigration court's jurisdiction, again, as mentioned earlier, I was an assistant chief immigration judge, which essentially means that I was an employee of the U.S. Department of Justice. The immigration courts are administrative law courts, which means they are federal employees of the U.S. Department of Justice who report up through the Attorney General of the United States and up to the president, so through the executive branch. The immigration courts are really tasked with determining removability of individuals from the United States. The judge does wear a robe. So they have a courtroom. The judge oversees the proceeding. And then there is a prosecutor from the U.S. Department of Homeland Security that is also in the room. And that person is essentially bringing charges or immigration violations, allegations of immigration violations against an individual. And on the other side, there is a right to counsel in immigration proceedings, which means that there is often an attorney in the room. I am now back to private practice after I was terminated from my position after almost 4 years in February of this year. And so I am back on kind of the defense side where I represent individuals in these immigration court proceedings. Essentially, the jurisdiction, again, is about removability from the United States. So the first job for any immigration judge is always deciding, can this individual be removed from the United States? So the number one question is always, is this person that is in front of the judge a U.S. citizen? Obviously, we have no jurisdiction over U.S. citizens. As immigration judges, they cannot order a United States citizen removed from the United States. And so essentially, the prosecutor is providing this charging document called a notice to appear. It's similar to like an indictment. And there are 2 types of hearings in immigration court: the master calendar proceeding, which essentially is like an arraignment. And so as an immigration judge, I would oversee the proceeding. I would make sure I'm determining that the person in front of me is the person that's named in the charging document. I'm making sure that that person knew their rights, so the right to have an attorney. An attorney is a due process right for immigrants in removal proceedings, but they are not paid counsel. It's not a right to paid counsel like it would be in a proceeding, in a criminal proceeding in the United States. So individuals can pay for their own attorney and they have a right to bring an attorney, but it's not a U.S. government expense. So essentially, it's determining, is that person removable from the United States? The entire proceeding is governed by statute. So it is passed by Congress, the Immigration and Nationality Act, and various iterations of that act and other acts passed by Congress that give the immigration courts their jurisdiction. And then, of course, there's constitutional arguments. So many of the codified Immigration and Nationality Act parts are based on constitutional protections. So again, there's the 2 parts. First, determining, is this person removable from the United States? Who are they? DHS prosecutor has the burden to show that this person is in fact an immigrant, that they've either entered unlawfully or committed some other immigration violation. And then if that is determined, so once a determination is made by the judge in immigration court that this individual is removable from the United States as charged, based upon international law and statutory law, the immigration judge would also evaluate then, does this individual qualify for relief from removal? So you all many of the cases we hear about in the news are fear-based relief cases, so asylum, protection under the Convention Against Torture, essentially different applications where immigrant respondents, which is how the judges refer to individuals in immigration court, those respondents can apply for these different forms of relief if they qualify under the law, and then essentially have a trial and present their cases. And that usually involves testimony, often in at least one other language. Sometimes I had a docket when I was a judge of a lot of Central American cases. So sometimes we even had two interpreters where maybe an indigenous language like mom was being interpreted to a Spanish interpreter, interpreted to English. So, really diverse caseload, and interpreters are always in the court, and then individuals can present witnesses on their behalf. It is an adversarial proceeding. So again, a DHS prosecutor is arguing against that non-citizen respondent who has their attorney, if they're able to afford one, or if they're able to find one pro bono,
Okay.
defending them. So yeah, it's an incredibly, I will say before we keep going, it is an incredibly difficult job, incredibly difficult. The stories that immigration judges are exposed to are very difficult. It's often stories of torture, political violence. It may be based on gang violence. It may be based on a number of different situations in the world, and it's people from all over the world. And so it is incredibly taxing. The judges work extremely hard. I was really lucky to be able to oversee. We do have a lot of talented judges on the bench, and those judges often hear 3 or 4 trials a day of these really, really difficult circumstances.
So you describe this system, and I also want to understand the accessibility of the public and journalists when it comes to this system from you, Lisa and Mohammed. I mean, is there a unique challenges and obstacles when it comes to transparency and accessibility to both the court proceedings and the court documents? And I'd love to start with you, Lisa.
Sure, and thanks so much for having me. And, the Reporters Committee for Freedom of the Press was alerted to the fact that a lot of journalists who come to us to get information about how to access court records were also going to come to us to find out how to access immigration court records, given the incoming administration's focus on deportation. And so we jumped at action and we put together an immigration reporting guide spearheaded by my colleague, Jen Nelson, who's here tonight. And that guide focused on accessing immigration records across multiple federal agencies, but in particular, accessing immigration court proceedings, because so many journalists have never covered these beats as they do other court beats, and needed to know where to go and how to get access to the court and its records. And one of the first things that really becomes apparent that's so different from federal court is that immigration court records are not accessible to the public by typical methods of docket searching and going to the courthouse and pulling records from open cases and proceedings. The record of proceeding for an immigration court is a record that a litigant, a participant in those proceedings, can seek through a form where they make a waiver of certain privacy interests and they get a copy of their record of proceeding. But to anybody who is not a member, a party to a proceeding, you have to go to the court and ask for those records as a FOIA, which is, as many already, it's like a trigger word to reporters. This is going to be a burdensome process, right? Some reporters work with litigants and their attorneys to get access to records in any particular case, or urge a litigant to obtain a copy of their ROP, their record of proceeding, so that it can be reviewed and used in reporting. But it can be very challenging typically to access those records. Another interesting thing that we learned, because we weren't focusing on this area of reporting for a while, is that many of these proceedings are recorded. There are audio recordings made, and those recordings can be transcribed and made a part of the record of proceeding, so it can be utilized on any appeals. So that too is an area for reporting and for sort of greater insight and understanding of what may have occurred in a proceeding that a reporter didn't actively witness themselves. And that brings me to the next big area that we hear a lot about, which is how do I go observe immigration court proceedings? We've done some field work a little bit in this area, and we've done some research. And what we come to is that immigration courts can be run very differently depending on what city you're in and what court you're in. There are some immigration courts that are extremely active on border areas, and for which a lot of reporters in that region probably already know the ins and outs of how to get into court and what to expect. But we've heard through our hotline from a lot of reporters who are very new to this beat and have experienced being thrown out of immigration court proceedings by judges who wanted to know who's here. There's going to be sensitive information discussed. As was previously described, a lot of these proceedings involve fear-based efforts to remain in the country as a non-citizen. And so the discussion might include very sensitive topics involving the need for asylum. And so there's some tension, right? Immigration judges might feel like it's improper to have witnesses in a courtroom during that testimony, and they are empowered to make limited closures. But the presumption is that the public and journalists alike can witness these proceedings absent those specific conditions being meant for closure. And we've heard from some journalists who were honestly identified themselves as journalists and were specifically told to leave. And we've filed letters on their behalf, trying to further educate immigration judges who aren't maybe used to seeing reporters in their courtroom, what ought to be done in those cases and why
Is that
reporters-
legal to just kick a journalist out of the proceedings?
No, it's not. Unless there is an order that applies to everybody in the public that precludes them from visiting the courtroom. But singling out a journalist for exclusion is not appropriate. And so these are matters that we have followed up on as well. But in fact, the regulations of addressing this issue specifically point out that if there are space considerations, journalists should have priority of seating over general members of the public. And that makes sense because journalists can act as the eyes and ears of the public. They're going to more widely distribute the information that they glean from witnessing those proceedings than any other member of the public. But this is all information that's available in our guide and I think has been of value to reporters who are new to this beat. And we could talk a little bit about other facilities-based access issues and things that have come across our hotline, but I'll leave that.
Well, before we get to that, I mean, I have a specific question for you, Hamid, but is there anything you'd want to add to what Lisa just described in the general sense?
Yeah, I mean, I think I've gone to immigration court for hearings, and I've had various experiences. Sitting in a hearing and being told by a judge's assistant to go check in to the front office, and I had to go wait for almost half an hour as they kind of went through my credentials and figured out what I was doing there. And finally, I was allowed back in. I was in a different city where I just walked in the hearing and was able to watch it. So I think that really speaks to the, various policies depending on where you are.
Now, you are not new to covering immigration, but I feel like under this administration, immigration is front and center to their policy, right? That they have touted mass deportation as their central policy. I mean, what has changed in the way or in the challenges you face as an immigration reporter in the last 8-9 months?
Yeah, I mean, I think the biggest thing that I often think about is just the amount of news that's coming and being able to stay on top of everything and report on these really important events in a thorough way, just because there's so much happening in every single agency that touches on immigration. I mean, you have the Department of Defense involved, you have HHS involved, you have DHS involved, the State Department. It feels like there are major stories each and every day.
Or several.
Exactly. Yeah. Several stories. So that has been my biggest challenge.
I mean, how do you, and I'd love to hear from you on this, Lisa, as well. I mean, how do you pick and choose where you focus? Because it feels like so many cases feel so urgent. So for example, I was just reading your story this morning about this deal with Iran, where a plane of Iranians who have asylum here or living here that are not American are being deported back. I mean, how do you make these choices?
Yeah, I mean, I think I typically want to be reporting something that, hasn't been out there already. So, something new, something that is, that we're bringing to the public first. I like to do accountability reporting. So, going back to cases and figuring out, what were the conversations, inside the room when, for example, Kilmar Abrego Garcia was deported. How were they talking about that deportation when the news first broke.
Which is the Maryland father who was sent to El Paso not El Paso,
El Salvador, yeah.
El Salvador,
Yeah.
for those who aren't familiar with the case.
Yeah. So, I mean, just a mix of, doing accountability stories, writing about the changes that this administration is making through human beings, walking through people's experiences and trying to show the public, what the impact is of this, really groundbreaking change in immigration policy.
I want to come back to something you said, Rebecca. I mean, you were recently fired from your job. This is a case that is ongoing in courts around the legality of what happened. You are one of over 100 immigration judges that were dismissed. What does that do to the court system? I mean, what kind of strain does that put on the court system when suddenly policy is changing, experienced judges are removed, and now temporary judges, military judges are being, or military lawyers, right, are being appointed? What happens?
Yeah, sure. I'm happy to take that one. And I think I'll also go back to your earlier question about just kind of how one is appointed as an immigration judge. It's very different from federal judge appointments. It is
Right.
literally applying for a job. So as an attorney, you have to be a licensed attorney. You have to have at least usually 7 to 10 years of litigation experience. So being in court, doing trial work, but essentially it's a job application. And the reasoning behind that really was to make it kind of a civil servant role that is outside of the political realm. And so the judge is really looking at the facts and the law in front of them in their courtroom and making that decision. So generally under the Civil Service Reform Act, there are certain protections that apply to all DOJ employees. So as I mentioned earlier, immigration judges really just are employees of the Department of Justice. They must be lawyers. They must have certain experience, but they go through a rigorous application process, hiring process, multiple interviews, security clearance to get those positions. Right now, what we're seeing again, I was fired on February 14th, Valentine's Day, along with 6 other chief judges, and we were kind of one of the first waves of firings. But there have been, as Layla mentioned, they're up to, we know of 100 now, up to almost 150, either terminated or kind of forced out or deferred resignation kinds of programs. I would say I just find it extremely scary for the court system itself. And I think it places an immense burden and strain on the court system. First off, I will say just knowing the judges, and as I was a chief judge who oversaw, I had about 32 judges that I supervised. It puts an incredible strain on the judge when they're worried about their own job and feeding their family and, being fired from one day to the next. And it really does affect, I think, the quality and quantity of decisions. There is a real fear right now and real belief among the judges that government officials above them at DOJ are looking at their statistics. How many grants of asylum are they giving? If they're giving too many, that's one major school of thought right now, is that maybe it's based on the number of asylum grants that are being provided. And as you all know, a trial is a trial. So each person is different. Each person has a story. Some judges might be hearing, for example, I heard a children's docket some weeks. So I had a lot of children's cases, which actually tended to be maybe higher grant rates just based on the different forms of relief available to unaccompanied children in the United States. Some dockets might focus on Afghan refugees. There's different types of dockets. And so having this strain on the judges when they feel like if they decide too many cases in favor of a non-citizen, they would be fired, that is incredibly difficult. And it's also hard to imagine a fair day in court in that situation.
Hamid, how has this impacted the public's trust in the immigration courts and people's trust in the immigration courts when they go, for example, to have an asylum hearing or other type of hearing in the immigration courts? In your reporting, how are you seeing people's views of the courts shift and change?
Well, I think in general, the courts, are quite opaque and, it's hard for the public to really understand the ins and outs of what's happening because, you really are at the whim of the government or the attorney involved in the case to understand the broader picture of the case. And I think as a result of that, people don't really understand the courts very much. And so there is a lot of skepticism and, pessimism about, the final results and what the intention of the judges are in these really pivotal cases.
Lisa, how long have you had this hotline open for journalists?
50 years.
50 years. And have you seen a change in the types of calls and the number of calls you're
Yes.
getting?
Absolutely. Our hotline, it's been around for 50 years. It's a really good bellwether of what is causing the most stress and strain on journalists in the field.
Yeah.
It was prescient that we had a guide in the works for covering immigration because it was like a light switch went off this winter. The flood of calls that we received from journalists who wanted to cover immigration court and needed help, wanted assistance and advice on what to do when covering Homeland Security officers in the hallways of immigration courts, what to do if they wanted to cover the implementation of judicial warrants that Homeland Security may obtain to make arrests in private spaces and the homes of others. How do they get access to those records? What to do if they're covering federal court? And numerous habeas petitions involved in immigration cases are now being heard in federal court. But there are federal rules that limit access, immediate access to electronic records in immigration matters in federal court. What do we do about that? And I will tell you so much more. Just even non-citizen journalists fearful for their own ability to continue reporting and not be chilled. It's been an absolute shift, a complete shift in the needs of journalists in the field. And our response has been very swift to provide support.
And what type of support are you providing? I mean, because I think it's a bandwidth problem too, right?
Bandwidth for us or?
No, bandwidth for these smaller newsrooms.
Yeah.
So Hamid, you work at the New York Times where I'm sure there's a lot of resources, but when it comes to these smaller newspapers, radio stations, TV outlets in smaller communities, what type of support can they turn to your organization for? Or maybe you can give them advice on turning to other places.
It is not uncommon for our hotline to receive calls from a typical working journalist in America today. And for many, that means somebody who does not have an in-house lawyer at their news organization, or maybe working freelance and publishing on numerous sites. And so when they have a question about what are their legal rights, they call us.
Mhm.
And so in terms of bandwidth, we're talking about many journalists in nonprofit news organizations, small news organizations, or independently working in the field who need legal advice urgently, and then that's when they call us.
This has become such a politicized topic, right? It's in the news constantly. Rebecca, we heard you describe the concerns around immigration judges and whether their decisions would impact their jobs. I'm curious what that does also, though, to the journalism itself. I mean, in your work, Hamid, are you also dealing with blowback you haven't seen before when it comes to the type of coverage that you do?
Yeah, certainly. I mean, I think, this administration has been quite vocal on social media and criticizing stories. And certainly I've been on the receiving end of that. But, I think the goal continues to be for us to be independent reporters and to continue to follow the news. So I don't really think it's, despite that blowback, it hasn't really changed our direction on this, really important topic.
Yeah. The other question I have for all of you really is I think it can be confusing for people in these big cases, like the student protesters, Mahmoud Khalil, Marcin Mahdawi, the Maryland man that you just mentioned, the interplay between the federal courts and the immigration courts, because often there's two cases going at the same time. I mean, ultimately, what happens that decides their fate? Is it the immigration court? Is it the federal court? Is it a combination of the two? And I mean, any of the panelists can start.
I'm happy to jump in. It is very confusing. I will just say it is confusing for lawyers. It is confusing for judges. So it's so wonderful that journalists cover this and try to keep up with it because it is not an easy topic. So essentially, I think one important item to remember is that for removal, so the actual case in which an immigrant respondent is being taken into immigration court and there is a request to remove them from the United States by the U.S. Department of Homeland Security prosecutor, that case law that the immigration judge is going to be hearing the facts, and then they're going to be applying the law to those facts. That law comes from case law through the Board of Immigration Appeals, which is the appellate DOJ arm of the immigration courts. There's been extremely robust publishing of cases by the Board of Immigration Appeals called the BIA, and that is precedential decisions that do bind immigration judges. So for example, you all may have covered, there was a recent bond decision, I have it right here, Yahure Hurtado, which was essentially a case that involved detention. So this has been a landmark case in that it has restricted abilities of immigration judges to grant bond during a removal proceeding. So again, removal proceedings involve whether this person has a legal right to be in the United States, whether they are removable from the United States, and then if they are removable, whether or not they have some sort of relief under the law. The other thing, so for example, that case from the Board of Immigration Appeals has limited the ability of individual immigrants to be bonded out of detention while they're fighting their case. And that coupled with ICE action, kind of rounding people up in these larger raids, and then putting all of the individuals into immigration detention and removal proceedings. So that's kind of the immigration court piece. The federal courts that we hear about generally deal with constitutional issues and deal with habeas, like habeas corpus, for example, individuals bringing a challenge to their detention by the government. There is very diverse case law in the United States. So as I mentioned, the Board of Immigration Appeals, which governs all immigration judges, above that, it really is regional. So for example, in where we are here in Virginia, we're in the Fourth Circuit Court of Appeals. That means that there are certain asylum cases that are very winnable here. For example, family-based claims for relief for asylum can win here. In another circuit, they may not be winnable. So it's very regional as far as which cases may win. And some of the immigration detention we're seeing also involves transferring people. So transferring bodies, and this is the idea of habeas corpus, challenging the detention of individuals, the conditions of that detention, whether or not it's lawful. So there's been, for example, a number of federal courts that have held that this Board of Immigration Appeals decision is not lawful and have been releasing individuals while their removal proceedings are moving along.
Is there a sort of, Hamid, you mentioned briefly, like when you think about the types of stories you decide to tell, it's about accountability, it's about things people haven't heard before. Is there a sort of guiding thought as you look at immigration in this moment that you use in your coverage when you're thinking about a story? I mean, maybe you have a specific story that sticks with you that is sort of symbolic of this moment.
Well, that's a great question. Most days I'm just trying to, survive the onslaught. But, I think I think there's so much happening, and sometimes readers think they see things, the policies come out, and I think our my sense is trying to explain what's new, what's not new, how unprecedented is this? How much will this change the system? And I'm trying to, pick my spots to show exactly that, to have the ability to look back in this year and say, okay, I, covered the biggest moments, the biggest cases, well.
And before, I'm about to turn it over to questions. I don't know how the time passed so fast, but for both you, Hamid, and for Lisa, I want to understand better how much time you're spending reporting and reporters who are calling you spending reporting, and how much time you're spending putting in freedom of information requests, suing, trying to get access to proceedings, like just getting to the place where you can look at what you're dealing with. Do you want to start, Lisa?
I can't speak to the experience of all the reporters
Right.
in the field. What I can say is that we've tried to effectuate some systemic changes. We've been to limited success, mainly focusing on access to federal proceedings on immigration matters, where the Federal Rule of Civil Procedure 5.2C basically establishes a limit on typical online PACER access to immigration court records. It's a reflection of a couple things, but what the advisory notes basically tell us is that in 2007, the Department of Justice came in and said, immigration court records contain a lot of sensitive information. It's too hard and cumbersome for us to redact all of that information. So how about we just decide that we don't redact that information? The records go into a federal proceeding, but those records aren't electronically available. Individuals need to go into court and physically ask for a copy of the records, and then they get a fully unredacted copy of these records. And with the rush for reporters covering this issue, we were hearing from a lot of folks in the field that this was incredibly unworkable. It was both like an overbroad and an unduly narrow solution to a problem. And so we have sent letters to numerous federal courts, including the District of Columbia's federal court, asking for the implementation of a new standing rule that would essentially render these records available on PACER within 10 days of a case being initiated, unless there's an objection from a party. A similar standing order has already been implemented in the District of Massachusetts. No one's really taken us up on our suggestion otherwise, but we're going to press forward. And instead of also just making those broad asks, we've been representing news organizations, in particular dockets, and asking the court to exercise its power to render those docket materials available online, which Rule 5.2C does permit. Because what we were just trying to accomplish is an opening up of these records to the extent that we have any influence or ability to do that. We want to make sure that the public gets the same information that any other member of the public or reporter would have if they just walked into the courthouse and requested the records. I imagine the clerks of the court would really like this too, because they're probably just getting a lot of reporters running in asking for the same records and the same hot cases over and over again, and that seems burdensome to me. But that's a key area of our advocacy, is just trying to alleviate some of these pressures.
Okay.
Yeah, definitely. I mean, I think unlike the federal cases, it's really hard to track down and get the full case file in these really important cases, or sometimes not even the biggest cases. You hear of a case in a state that's far away. You want to understand the evidence. You want to understand how this person was apprehended, and that can be incredibly difficult. So a lot of the work is really just tracking down this information.
Okay, I'm going to turn it over to questions from the audience to hear what you're curious about.
Hello, my name is Monique and I work with DC Safe and I'm a domestic violence advocate.
We can't really hear you. Sorry, if you don't mind speaking up a little bit.
Sure. Hello, can you hear me?
Yes.
Okay, great. My name is Monique. I work with DC Safe and I'm a domestic violence advocate.
Mhm.
And a lot of the clients that we see can have immigration statuses that range. One of my questions is, I know that you talked about how there is no jurisdiction in immigration court to remove a US citizen, but there are a lot of stories that are coming out of US citizens that have been targeted by ICE and they've been held for a certain amount of days and then they end up being released. And I'm just wondering what's the due process, or what are those rights, I guess, while someone is being held, even though they are living here and it seems that they're just being targeted because of like racial profiling. So yeah, that's my question.
I'm happy to jump in on that. I mean, that again, there's so many intersections of different areas of law. So essentially, that, and we do, for example, at my law firm, we have a lot of folks coming in and asking for consultations on that. And generally we say, sorry, we can't help you because we do immigration. Here's some civil rights attorneys, because you may have some sort of claim based on that unlawful detention. And again, that goes back to the federal proceedings, federal court, constitutional claims, when there's an unlawful detention, when there's racial profiling, kind of the due process constitutional arguments. So immigration court, the judges don't see those individuals. I have not heard a lot of cases where ICE is actually charging those individuals with removability from the US. It's a simple, they're detaining them along with everybody else that they're sweeping up. And then once they figure out who everyone is, they're releasing those people. But they would have some sort of civil remedies.
Get a question down here.
Do you have any information? Do you have any information on the increase in caseload, the actual statistics of what you're facing? Has there been a big increase under the Trump administration? I don't think anybody mentioned this earlier. I don't get much in the media. Does anybody have any insight?
Well, I do have two stats in front of me, even though I don't cover immigration. I just wrote these down because they shocked me. There are 2 million people, more than 2 million people waiting for asylum hearings and nearly 3.5 million cases backlogged in immigration courts. Is that normal?
Yes.
Oh, wow.
So I think I'll just do my best to kind of explain, like the 2 million people waiting for asylum. Generally, that's, I think, referring to USCIS, which are people that came forward and requested asylum and are waiting to have an interview with an asylum officer. Immigration court, if that person has the interview and they do not win asylum with that officer, they will be referred to the immigration court, where they have one last shot at asylum before an immigration judge. But really, I would say the change is coming in the form of what the docket looks like. So it used to be that almost all the cases were non-detained. Now it's changing that most of the cases are detained. And so in immigration court, the Immigration and Nationality Act and the regulations have much stricter timelines for detained cases. So for example, they're going to move at a much faster pace. It's harder for individuals who are detained to access counsel, to get their evidence together, for example, to present at a trial. So, when I was a chief judge between 2021 and 2025, we had over 3 million, I know, in the backlog, close to 4 million. It would kind of come and go. But a lot of what we're seeing now is an increase in the detained versus the non-detained cases.
Well, I'll just add to that really quickly. I mean, one phenomenon now that we had never seen before is really using the immigration courts for ICE enforcement. So ICE prosecutors showing up and dismissing cases on purpose with the sole intent of the immigrant walking out of the courtroom and being arrested by ICE. And the hope for the government is to be able to deport them rapidly outside of that immigration court process. So that is like this totally new phenomenon that we've seen, these really intense moments in New York City, for example, where ICE is arresting people outside of courthouses.
And this presents a particular reporting problem. You
Yeah.
get calls from reporters who are at immigration court, witness these events, they pull out a camera, they want to document it. And although there is a regulation that permits photography in federal buildings, absent, obvious exclusions, the Executive Office of Immigration Review has a newer policy that specifically prohibits photography in these spaces outside in immigration court buildings. And so reporters are butting up against these restrictions that they may not have otherwise been aware of, and or something important and newsworthy is happening in front of them, and they're just going to want to document it anyway. And this has posed a lot of confusion and particular problems in news gathering.
Good evening. There we go. Good evening, Dr. Kevin Beck.
Oh.
Dr. Kevin Beckford with the Pretrial Justice Institute. First and foremost, thank you so much for sharing your insight and for your time. This was incredibly insightful. I'm keen to know if there are any proactive reporting strategies, campaigns, communication tactics that are currently being employed to represent issues of immigration and justice at this time, right? A lot of the conversation, seemingly so, has been, in response to attacks, right? But I'm just keen to know if there are any maybe bright spots or opportunities to get ahead of reporting and to own narrative. Any thoughts on that?
I think this one is you, Hamid. I know you're looking.
I mean, I don't know. I mean, I think like there have been a lot of advocates who are trying to stay ahead of the curve and trying to tell, the story of people who are being affected by these operations and the expansive immigration enforcement, effort by the Trump administration. But, as far as strategies to get ahead of that, a little bit out of my lane, but certainly I do think a lot of groups are trying, but they are under a lot of water trying to respond to what's happening on the ground.
The panel has been mostly about difficulties in getting access to information about immigration enforcement, immigration courts. I'm struck by the fact that it's actually not. It's less difficult at the moment to get that sort of information than it ever has been before, because DHS and ICE are dumping huge amounts of information, photographs, records out in public that we've never seen before. It's very common for them to put out press releases saying, here are the worst of the worst, and here are the photos of these people and their names and their ages and maybe the country or hometown they're from. What is the panel's view about the sort of disconnect between the story that this administration is telling publicly? I've covered many administrations before that, and you would find it very difficult to get a photo of anyone who was, even if they were ordered deported, even if they were a war criminal in another country, very difficult to get that kind of information. And now on a daily basis, we see lists and lists and huge numbers of photos of people that have been sent to various countries around the world. What is that dynamic or disconnect between getting access to these records that you want versus the story that the administration is telling on social media, on Fox News, and in other places?
Well, I mean, I think the question always is the context in which those releases are sent. And so obviously, every single day I do get these emails of the worst arrested, but, that doesn't come along with a breakdown of, for example, in Washington, D.C., there was constant statements by DHS and the administration on the people that they've arrested, but it's unclear and they haven't said the breakdown of people who've been arrested and their criminality. So we may know of a few cases, but one of the questions that we've been asking is, how many, how does this represent the overall population that's been arrested? So I think we come across a lot of these cases, they want publicized, but we don't have the full context. So it's hard to understand sometimes how revelatory the information really is.
Yeah, and I think the other thing, at least in my experience, is some of these pictures will be released and the family won't have known where somebody went. And that's the only information they have on their family member. And again, there's no context or information about how viable the information is that's being shared with you, including things like the number of assaults on ICE agents. That's not broken down for us on whether somebody was shoved or beaten or, you know, what it is that constitutes an assault. So.
Hi. On your points about the proposal, I think it was you, Lisa, that's something that was instituted in the District of Massachusetts, a 10-day notification period before filings would become accessible via PACER or something along those lines. I never really thought about the lack of access, but I think about some filings that I've made for clients that include, you know, very candid details about clients' experiences, naming gangs, naming individuals in those gangs, and, you know, outlining the persecution. Is there, especially since a lot of these individuals don't have counsel and might not be so savvy to respond to a notice period like that, is there, how do you respond to concerns about client's ability to be candid in its filings?
The standing order, just for clarification, in the District of Massachusetts is a 30-day initial period where those records are not available to the public, which actually can be really problematic because a lot of action happens in the first 30 days. But that standing order, as well as the proposal that we've put forward for a 10-day period, all include a period of time in which a litigant can object to their records being made available on PACER. And that objection would be heard before any any PACER disclosures are made. But to be clear, under Federal Rule 5.2C, from the moment the case is initiated, those records are available upon request, unless there is a protective order that limits their disclosure or other redactions are made pursuant to an order of the court or agreement of the parties. And that's something that any litigant should be aware of. And one of the reasons why our criticism of the existing practice is that it's both too narrow and too overbroad. It doesn't seem to serve any of the stated interests. And our hope is that our proposal, at the very least, makes clear to everybody with an interest in getting access, or if necessary, protecting access, what a reasonable time period makes a reasonable time period available for those issues to be addressed before the court.
We'll take one more question and then we'll wrap up.
Hi, I'm so glad to be the last question. I wanted to ask a little bit more about this concept of firing judges, which I just think is a really strange idea, especially if the idea is to make this less political. And I'm curious if other administrations have exercised that power, if this is unprecedented. I imagine on the scale it's unprecedented, and if there's been any discussion around changing the process. Obviously probably won't happen right now, but if there are conversations about making things not that way.
Yes, absolutely. I'll take this one. Essentially, there's always been immigration judges when they apply for the position, they're selected after a rigorous application process. Essentially, they get a 2-year probationary appointment, and that's been something that's been on the books for many years under many administrations. And so the judges undergo a very rigorous probationary review where they're essentially reviewed by everyone, the prosecutors, the defense, the interpreters, everyone reviews them. Attorneys review their decisions. And then and so they're essentially appointed for 2 years by the Attorney General based on these applications and selection. And then if they pass probation, as in the Attorney General reviews their reports and decides to convert them, they're given a permanent appointment. The probationary period has always been somewhat politicized sometimes, I would say, as in, I would say both Republican and Democratic administrations have complained about it, said, well, we think, these judges on probation are should have been converted or should not. And a lot of times it would depend on the timing of a presidential administration. So that the 2-year probationary firings are not new. And essentially it wasn't a firing. It would be this 2-year temporary appointment that was not converted to permanent. I think the thing that's unprecedented now is just the number and the fact that it's permanent. So for example, my appointment was, I passed probation, right? I went through all of that. I got my permanent appointment from Attorney General Garland. So I think that's the change, is a lot of the permanent judges are being fired. My 2 assistant chief judge colleagues who were fired along with me on February 14th have been reinstated. They're the first two that have litigated at the Merit Systems Protection Board, so that they were reinstated Friday night. And it continues to be litigated, but they did win their case. And that's the first, I think, immigration judge firing case that's gone to the Merit Systems Protection Board decision phase. So the probationary classes of judges, they're also, I mean, these judges, it takes a lot to train them. I was involved in hiring, training, just to get them familiar. Many of them actually don't come from immigration law backgrounds. They may come from like JAG, military judge backgrounds, and it takes a long time to get them trained up. And so to have them be trained and then just be fired without a review of their probation reports, which is also a lot of work, which is what's happening now, is I think the kind of the travesty. And yes, there's a lot of push to make immigration judges actual federal appointed judges that would not be under this process.
Okay, that's our time. Thank you so much for coming and thank you for sharing your expertise and what you do.
Hi, everyone. My name is Misty Thomas-Zaleski. I'm Council for Court Excellence Executive Director. And so it's my pleasure to thank all of you. You're phenomenal. The terrible thing about panels with speakers like you is that it ends with 20 more questions and more we'd like to know. But the good thing about the way CCE does these is you get to go out there, have a drink and a snack, wrangle one of these brilliant people and ask them questions because they're here in real life. So I hope you enjoy learning from these brilliant minds. It means the world to have you here. It means the world to have our sponsors who gave to help make this successful tonight. Some of them are here too. Gabby Bell from Organized Q is here, and others. But I hope you stand with CCE and pay attention to our work. If you're new to us and you came to this because you're interested in immigration or this issue, get to know our organization as well. You may have seen resources out there where we are trying to stand for excellence in evidence-based information, facts and accuracy when it comes to the many issues facing the District of Columbia federally right now and locally. So come talk to, there's members of our staff. I'd love to talk to you about the work we're doing here, and putting these wonderful programs on is just one of many ways we try to educate the community. Thank you all for being here. Come celebrate with us.
I don't get to do this.
Yeah.